Judicial review represents the means by which the courts control the exercise of governmental power. It is designed to ensure that public bodies which exercise lawmaking power or adjudicatory bodies act within the powers. Judicial review is concerned with the legality of decision made, not the merits of the particular decision. The power conferred on public bodies may be given by Act of Parliament. The principal question to be addressed here is whether the person, such as a minister or a public body, has acted intra-virus or ultra-virus, and whether the decision-making process requires the use of natural justice. The Human Rights Act 1998 extends the scope of judicial review in that any failure on part of a public body in respect of human rights is subject to review by courts. Subject to changes which have been brought by this Act, the courts seek by judicial review to ensure four objectives, which are that Acts of Parliament have been applied correctly, that discretion conferred by statute has been lawfully exercised, that the decision maker has acted fairly, and that the exercise of power by a public body does not violate human rights. Next, in order to obtain permission to bring an action for judicial review, the applicant must have sufficient interest in the matter to which the application relates. This can be known as the sufficient interest test. The test of sufficient interest was provided in Art and Inland Revenue Commissioners Ex parte National Federation of Self-Employed and Small Businesses. The House of Law approach was that the question of standing should be examined in two stages. At first instance, standing should be considered when leave to apply is sought. At this stage, the court is concerned to ensure that it prevents abuse by busybodies, cranks, and other mischief makers. If leave is granted, the court may, at a second stage, when the merits of the case are known, revise its original decision and decide that after all the applicants do not have sufficient interest. Each case must therefore be considered on its own particular legal and factual issues. However, there are some guidelines offered by Peter Kent in an Introduction to Administrative Law, which include examining the case law, look at the statute in the question, consider the nature of the complaint, and also how serious is the wrong. The courts dislike the possibility of there being a lacuna in the legal system. If there is a chance that an aggrieved person will not have an alternative means of challenging the decision in question, it increases the likelihood that the applicant will satisfy the local standard requirements. However, it can also be said that due to the restrictions in applying judicial review, although local standard is to prevent floodgates, but because of some of the limitation, it has caused the occurrence of loopholes. And my teammates are going to introduce the following parts accordingly.
According to Section 31 of the Senior Clerk Act 1981, the court shall not grant leave unless it considers that the applicant has a sufficient interest, which also known as local standi or standing, in the matter to which the applicant relates. As per Lord Scammon, the need for sufficient interest is to prevent any abuse by busybodies, cranks, and other mischief makers. It therefore ensure cases are genuine and avoid unnecessary interference with administrative decision and processes. Applicants for judicial reviews are generally divided to four types, which are individuals whose personal rights and interests are affected by the decisions, individual concerned that a decision has affected the society as a whole, pressure or interest groups who believe a decision affects the right or interests of their members or society as a whole, and individuals claiming for judicial reviews for a breach of human rights under the Human Rights Act 1998. As mentioned above, individuals have standing to seek judicial review where they have been affected by the action of a public law body. Although such cases will depend on the facts of the case and is determined by the courts exercising its discretion, but it will be relatively easy to establish sufficient interest if the individual is affected by the decision despite directly or indirectly. There will be a clear indication of sufficient interest if a person's property or livelihood will be affected. For example, in Crown against Ware Valley District Council, ex parte Binks was directly affected by the decision of the Ware Valley District Council to issue her a notice to quit her takeaway food caravan without prior notice or any accompanying reasons. In contrast, individuals, busybodies such as a well-meaning citizen who is upset on Binks' behalf would not be able to apply for judicial review to challenge the District Council as they had not been directly affected. Other examples of personal individual sufficient interest are shown in Smith and Secretary of State for Home Affairs, where the students who had entered the country as students of Scientology challenged the decision of Home Office not to allow them to remain once the permitted period of stay had expired. In this case, the students had sufficient interest for permission to be granted as they are directly affected by the decisions. Other than that, in the case of Crown against Secretary of State for the Environment, ex parte Ward, a gypsy living on a caravan site was held to have standing to apply for an order requiring that the Secretary of State should direct the local authority to fulfill its authority duty to provide an adequate site. Standing was also granted to Mrs. Gillick, the mother of several daughters, who wished to challenge a health authority over its policy relating to contraception for young girls. Thus, standing will be granted to the individual who would affect or had affected by the decision or action of the public body.
How relevant would locus standi be, if you may ask? The term deemed and also supported by the Parliamentary Statute, Section 31, Subsection 3 of the Senior Courts Act 1981, would be sufficient interest. Then only there would be grounds for locus standi to occur. Now, locus standi limits the ability as of the means of a judicial review because there is grounds of which how locus standi is to be determined by the sufficient interest test. As the determination is done whether the courts and also the individual is able to prove sufficient interest may be a challenge. That is how locus standi might affect a judicial review application. And whether an individual or group of individuals must be directly affected by the subject matter is also very important, or else the claim would be most likely be struck off by the judicial institution on grounds whereby the claimant has not been able to prove that there is and therefore there is no sufficient interest for the action, which means a Good Samaritan with grounds on locus standi would not be able to bring up a cause of action on behalf of another individual that is directly affected and also proven to have locus standi. Articles has also been published with close regard to case law, such as in the case of the Crown against Secretary of State for Foreign and Commonwealth Affairs, more commonly known as ex parte Rees-Mogg, whereby the concept of locus standi managed to be established by the Crown on behalf of the claimant in terms of the executive acting in ultra vires in setting policies in relation to treaties imposed towards the EU. Thus, the court held that the claimant failed as there was no locus standi in which it doesn't affect the people as a whole, as it does not touch any British parliamentary laws or statutes. Therefore, the term non-justiciable was used, which proves as a landmark towards a private citizen acting upon for the public, no matter whether it successfully brought upon a claim that succeeded or whether it failed, it's still a landmark. Another prominent way in which locus standi has impacted the grounds of judicial review, whereas the claimant fails, would be in the case of the Crown against Her Majesty's Treasury ex parte Smedley in 1985, in which there was not a doubt towards the locus standi as there was grounds for sufficient interest and therefore there was grounds for judicial review. The claim was unsuccessful, but serious facts and questions were brought upon the powers of the institutions in which how Her Majesty's Treasury acts upon on the name of the Crown and on behalf of the Crown. Locus standi has also impacted the doctrine of judicial review, as which in a more recent case development in the case of the Crown against Home Secretary ex parte Bogler in 2001. Now, the case revolves around the premise of a parent of a minor that was murdered, and the claimant wanted to challenge the imposed tariff on the setting of the minimum sentence on the earliest release of his son's convicted murderers. Now, the case is a landmark, although the case was dismissed due to its merits, but the claimant has proven he has fulfilled the criteria of a successful interest, but he still had no locus standi, as the proceeding was deemed a criminal matter and is between the defence and the Crown only. As there was a case of conflict of interest, now the rules of locus standi has also limited the applicability of judicial review. In modern context, in the case of ex parte Beatrix, a factor of public interest standing must be fulfilled as well. Besides the key words used to deem the Samaritan has a direct effect and also a genuine in nature rather than taking the courts out on the rules. As the evaluative measure, there must be certain rationales to be fulfilled which somehow cross-decks with the private law, burden of proof, balance of probabilities towards the merits of which brings around locus standi. And on that note, I would like to hand over to my groupmate Win Xian as of the following. Thank you.
Next, let's look at the standing of pressure or interest groups on judicial review. Generally, pressure or interest group may be able to claim sufficient interest if a decision affects their interests or those of their members. These groups would include, for example, professional bodies and trade unions. For instance, in the case of Crown and another against Westminster City Council, an association representing the residents of 2 squares in London successfully challenged a traffic order made by Westminster City Council which affected their residential areas. Besides, in Crown against Liverpool Corporation, ex parte Liverpool Taxi Operators Association, an association of taxi operators wishing to challenge a decision to increase the number of taxi licenses available. Obviously, the association had sufficient standing in this case. Furthermore, in the case of Royal College of Nursing against Department of Health and Social Security, the Royal College of Nursing had the standing to challenge the departmental circular concerning the role of nurses in abortions. In addition, in the case of Crown against Employment Secretary ex parte EOC, the Equal Opportunities Commissions, who have a standing in this case, challenged the statutory provision that discriminated against female employees. These cases involve organizations seeking to challenge decisions which affect their own members. Accordingly, the standing requirement is relatively easy to satisfy since each of their members would have individual standing.
So the standing of pressure groups acting in public interest has been a more complex issue. Literally, when an organization acts on behalf of the public, it indicates that each of its members does not have individual standing. So despite the fact that every one of us belongs to the community of citizens, this remains the law. In ex parte Rose Theatre Trust Company, the court laid down several grounds for consideration in granting interest. Firstly, assertion of an interest by a group does not necessarily mean so. Also, sufficient interest is not conclusive, even when thousands of members join a campaign. The question of sufficient interest is not purely within the discretion of the court. And finally, sufficient interest does not necessarily entail direct financial or legal interest. However, courts seem to be more lenient in granting interest after the case of Rose Theatre. In ex parte Greenpeace, the court held that the Greenpeace had sufficient interest as it was a well-established and respected pressure groups in which it had deep experience, expertise and financial resources in environmental matters. However, the court warned that Greenpeace or other pressure groups would not automatically be held to have sufficient interest in any further case. Next, in ex parte World Development Movement, standing was granted as the group had 20 years expertise in providing financial aid. Also, it had consultative status with the United Nations bodies. In addition, in ex parte Equal Opportunities Commission, the EOC successfully sought a declaration of incompatibility regarding the provisions of Employment Protection Consolidation Act 1978 as its responsibility was to fight against sex discrimination. So up to this point of discussion, we can tell that from time to time, judges tend to consider the standing of pressure groups acting in public interest on a case-by-case basis by adopting a more inclusive or liberal approach. More particularly, the court repeatedly considers certain features of pressure groups as relevant to public interest standing. For instance, the court considers factors such as genuine concern, motive, the issue of public spirited, expertise, history, experience, responsibility, credibility, and also respectability. These features indirectly drafted a reconstruction on the rule of locus standi, aiming to give clearer views on validity of standing. However, they do lead to confusion as well. As criticized by Endicott, in granting public interest, a court should focus on whether or not it is in the public interest to hear the cases without dwelling on the issue of group interest. Also, the court remains silent on whether each of the factors carries civil weight or whether they are considered on a hierarchical basis. However, as seen in previous cases, it is sufficiently evident that expertise, experience, and financial resources hold stronger position among all the other factors. In this case, locus standi is restricted as judges do not put their focus on the spiritual factors like genuine concern and public spirited that much, as factor of genuine concern was approved only in the sole case of ex parte ICI. Interestingly, spiritual factors are often the main drives for underprivileged groups to challenge unlawful government actions. As proposed by Peter Kane, it is not right to refuse standing because of lack of competency or resources. Also, since power and prestige are determining factors or for respect and prominence, standing appears to be in favor only to well-known organizations. In R and London Underground, the court granted public interest as the society had long-standing involvement in historical railway preservation. Perhaps it should be pointed out that before reaching to a position of strong competency, majority of pressure groups started off as small-scale teams. So it is certainly unfair if weak groups are always denied standing before they gain respect, expertise, experiences, and financial resources as much as well-known organizations do. As Dicey proposed, rule of law requires that every person, irrespective of rank, is subject to the jurisdiction of ordinary courts. Thus, according to Lord de Block, when limitations on locus standi allows unlawful government actions to be insulated from judicial scrutiny, both rule of law and constitutional principle of government accountability are undermined. The Secretary of State for Justice in 2013 published a consultation paper titled Judicial Review Proposals for Future Reform, aiming to further restrict the ability of pressure groups to assess judicial review. In paragraphs 67 to 90, the rule on standing requires that the pressure groups to show that they have a direct interest in the outcome of the proceedings. Also, in paragraph 79 to 80, the paper proposed that government is in the best position to identify public interest. However, the proposals simply undermine the constitutional role of judicial review to keep executive within its power. In the United Kingdom, system of check and balances in separation of power plays a substantial role in preventing abuse of power. Therefore, when power to grant public interest in challenging unlawful government action is handed to executive, it would no doubt constitute to what Montesquieu termed tyranny. Furthermore, in order for courts to exercise proper function in judicial review, there must be someone to challenge the unlawful government action at first. As what executive recognized in paragraph 78, judicial reviews brought by interest groups are more likely to succeed than those brought by individuals. So the court should be lenient in granting leave to organizations who act on behalf of the public, as pressure of political accountability may be exerted by the people as well as pressure groups. In conclusion, the rule of locus standi to a very large extent restricts admissibility of judicial review application brought up by pressure groups acting in public interest. Awaiting further reforms, it is suggested that to increase successful rate of bringing an action, pressure groups may collaborate either with individuals directly affected or with commercial bodies. As shown in cases of Bone and also Hong San, pressure groups would presumably not be affected by restrictions as these parties hold direct interest in the challenges.
Now I'm going to talk about the Human Rights Act 1998 in the context of judicial review. Section 6 sub 1 of the Human Rights Act has extended the scope of judicial review in that any failure on the part of a public body to respect human rights will be subject to review by the courts. Thus, all public bodies are required to comply with the right protected by the European Convention on Human Rights, and judicial review proceedings may be brought to enforce that legal duty. Initially, the Act was intended to operate vertically, which is merely to bind the state bodies. However, because Section 6 sub 3 of the Act includes courts and tribunals in the definition of public bodies, the courts have a duty to comply with convention rights and have been able to extend operation of the Act to private bodies. An application of judicial review under the HRA will be successful provided that the test of standing is fulfilled. Section 7 provides that an individual who claims that a public authority which has not complied with this duty may bring proceedings against the authority in question. However, an individual may only do so if he is a victim of the unlawful act. The question as to who is considered as a victim is defined in Section 7 sub 7. This section states that a person is a victim of an unlawful act only if he would be a victim for the purposes of Article 34 of the Convention if proceedings were brought in the European Court of Human Rights in respect of that act. To further clarify, Article 34 of the European Convention states that the court may receive applications from any person, non-governmental organization, or group of individuals claiming to be the victim of a violation by one of the high contracting parties of the rights set forth in the Convention. As can be seen, under both the European Convention on Human Rights and the Human Rights Act 1998, the test of standing is thus very limited. Essentially, a party wishing to bring a case under either of these instruments must be a victim. In the case of Secretary of State for the Home Department against Nassery, the House of Lords explained the correct judicial approach to applications for judicial review based on an alleged infringement of a convention right. The brief fact of this case is that Mr. Nassery, an Afghan national, had travelled to the UK to claim asylum after his application to claim asylum in Greece was rejected. As a result, he was notified that he would be returned to Greece as under an EC regulation whereby an asylum seeker enters the third country from another member state, that member state will be solely responsible for determining the application. The applicant sought judicial review for the removal decision, which was arguably incompatible with Article 3 of the Convention. In this case, Lord Hoffman stated that when a court is hearing an application for judicial review, it is concerned with the decision-making process rather than the merits of the law. However, when an application involves an alleged violation of convention right, the court's approach must differ. The focus is not on whether the decision-making process is defective, but on whether or not the applicant's convention's rights have been violated. In the 1996 consultation paper on domestic incorporation of the Convention, the Labour Party has recommended standing to bring cases on convention grounds should extend to pressure groups who believe their cause may be prejudiced, and also representative group interests who consider their collective interests are disadvantaged. However, in introducing the Human Rights Bill, it was decided that the same test of standing as applied in the European Court should be adopted. Lord Irwin justified this view by stating that it is in keeping with this approach that persons should be able to rely on the Convention rights before our courts in precisely the same circumstances as they can rely upon them before the Strasbourg institutions. Conclusively, the Human Rights Act 1998 has introduced a new basis for standing, whereby Section 7 of the Act provides that only a victim of an act of a public body may make a claim. This test is the same as the test that applies under the European Convention on Human Rights. It is narrower than standing in other judicial review proceedings, and it also excludes representative bodies and interest groups taking action on behalf of their members.
On top of that, the granting of a remedy in judicial review proceedings is at the discretion of the court. The court may refuse a remedy if there has been a delay in commencing proceedings, or if the applicant has acted unreasonably, or the public interest in administration could be damaged by the granting of a remedy. One of the remedies is quashing order, which quashes the original decision. It is both negative and retrospective in nature, as we can see in Art and Criminal Injuries Compensation Board ex parte Rehn, and also O'Reilly and McMahon. The next remedy is prohibition, which is an order preventing a body from making a decision which will be capable of being quashed by a quashing order. It is therefore protective in nature. Further, mandatory order is an order which compels an authority to act, as we can see in the case of Petfield and Ministers of Agriculture, Fisheries and Food, in which a minister was compelled to refer a complaint to a statutory committee. Declaration is a statement of the legal position of the parties. Its effect is to nullify any previous decision which is incompatible with the statement of law made by the court. Besides, injunction is one of the remedy. They may be interim or permanent, prohibitory or mandatory, and are used to prevent a minister or administrative body from acting unlawfully. In M and Home Office, it was held that injunctions could be lied against ministers of the crown. The last remedy is damages, which pursuant to Section 8 of the Human Rights Act 1998. There are several limitations for the application of judicial review through the rules of locus standi, whereby the applicants must prove that they have sufficient interest in that particular matter. In locus standi, regarding pressure groups acting in public interest, consideration is on a case-by-case basis, where judges take into account several claimant-based factors. As a whole, standing in this class of person is restrictive. An application may also be brought for judicial review under the Human Rights Act, provided that the public body fails to comply the right protected by the European Convention on Human Rights. However, the applicants must also prove that they are the victim of the unlawful act. All in all, we affirm the view of Lord Diplock, whereby members of the society such as pressure groups and individual public-spirited taxpayers should be able to bring a matter to the attention of the court, provided they fulfill certain criteria. The criteria is that they should be able to prove that they have sufficient interest in the case where their rights have been affected by the decision of public law body. Besides that, they must not be considered as busybodies of mischief maker, which will lead to an abuse of the courts. As long as they can prove that they fulfill these criteria, then they should be able to seek justice through judicial review.